Hello, namaste, welcome to the print. My name is Amana Begam. The Supreme Court recent judgment in Abdul Samad case, where it rejected his petition against the Alimony and granted his wife the right to maintenance under the Section 125 of the Criminal Procedure Code, has again kick-started discussion on the right of Muslim women and gender equality once again, and rightly so, I would say. So through this move, and the court has basically reaffirmed the legal protection available to the Muslim women or to the women irrespective of their religious background. And this ruling suddenly turned into the talk of the town since it reminded the Indian people of the case of Shahbaz, which was a turning point in Indian legal and political history. So Banu's fight for the maintenance led to a court victory basically, and she was granted maintenance under the same section. However, the Indian government legislated the Muslim Women Protection of Right on Divorce Act 1986, which diluted this court judgment of Supreme Court to provide maintenance to Shahbanu. So hence, it was very natural that this ruling will bring a lot of attention and spark a wave of newfound curiosity, also mingled with relief and hope. Now, the whisper of change and speculation stir the air. Have the laws evolved, or does the past still echo in the present? So, while the judgment is very welcome step in ensuring gender equality and protecting the women's right, so especially after the Supreme Court judgment on triple talaq. So it's in, however, it is very important also to understand that Section 125 of CrPC provides financial support to any dependent, which can include a wife, children, and even parents or any dependent sort of thing, kind of a person who are in distress. And it is not only for the Muslim divorcees women. Also, this isn't the first time that court has ruled in the favor of Muslim women. After this Shah Bano case, the court upheld the right of maintenance of Muslim women in Daniel Latif versus Union of Indian case and Shamim Faruqi versus Sahib Shahid Khan case. So it's clear that though Section 125 provide legal recourse for Muslim women to protect their financial maintenance right, it is not codified personal law that automatically which automatically applies all women of the community in case of divorce. So Muslim women who choose to follow personal law and want to receive maintenance according to the 1986 Marriage Act, which provide them maintenance only during the Iddat period, they can do so. And those who seek maintenance beyond the Iddat period, they can go to the court and ask for maintenance under CRTC 125. Also, there is a no contradiction between both. The Muslim women can go for both option and receive their maintenance. So, however, this is an option, the 125. It is not the standard procedure. The Muslim women have to decide what she wants to do. It is another alternative solution for her. Another significant of this judgment, in my opinion, is that provision of maintenance can offer another layer of protection to the Indian Muslim women by imposing some boundaries on polygamy. So, since polygamy is still permitted under Muslim personal law, women whose husband marry again often lack any financial means to meet their need, which forces them to endure hardship. And even if they don't want to live with their husband, they have no other means and no other way to find a solution to sustain themselves. But having the opportunity to continue receiving maintenance even after separation would encourage those women to file for divorce without worrying about the repercussions. So men would also understand that they cannot just divorce their first wife or force her to live with the man while he go for the another marriage, and he cannot leave her without responsibility if even they marry the another woman. So that will put certain kind of bond practice of boundary on the practice of polygamy. But important question here: how many women would be courageous enough, aware enough, or even have their own agency to go to court and claim what rightfully belongs to them? Uh, from asking for the maintenance from their husband without their family support and against the societal pressure, when most of the people in or the society believe that it's against the personal law getting the maintenance, because we have seen in Shah Banu case and how it triggered conservatives and radicals within the community. Even then Prime Minister Rajiv Gandhi, the most powerful man in India at the time, made a poor, hopeless elderly woman give up her right. It actually saddened me every time I think about how the most powerful Indian couldn't protect a woman, and how instead of standing by her side, he bowed down to the accommodate fundamentalist of the community. Anyway, back to the initial point. In a society where such a mindset prevails, how many individual women and their family will dare to approach the court? Can this be a real solution, or we have to look deeper to find the solution of this all the discrimination Indian Muslim women face in their community? The real solution of alimony is a family civil matter where personal law is often applicable. So, Section 125 of the CRPC is a CRPC criminal provision. It circumvents dispute arising from personal law and ensure women fair chance to get justice. But there is still the personal law, which is not fair. How, so we have to address the root cause, which is personal civil code. The personal civil code is discriminating, and many women will never get be able to obtain justice while the civil code, personal civil code, will remain there. So protecting women's right through legal remedies shouldn't be optional, I would say. While this judgment is a positive step, it is not a long-standing solution of the all the discrimination Muslim women go through, I would say. We need to implement a uniform civil code, that's it, to protect the legal right of Indian women, regardless their background and religion. So, moreover, this ruling of Supreme Court that the 1986 Act and under the section and maintenance under the section 125 can coexist in their respective jurisdiction. That is the most important thing of this entire judgment, because this sends a clear message that Muslim men cannot approach the court citing the personal law to absolve themselves from providing any kind of maintenance, as the petitioner in this case was arguing. And a lot of time, the All India Muslim Personal Law Board and their representative, they try to portray that the personal law supersede the constitutional secular laws, and that the section 3 of 1986 was wording in the certain way that this is the only law would be applied when it comes to the maintenance. So now court has said that that's not true. It will supersede other personal laws because it has a very different domain, but it cannot supersede when criminal codes come in the pictures. It cannot supersede the secular law. So this decision basically uphold the principle that personal law cannot supersede legal obligation to provide maintenance under secular CRPC. So therefore, it's confirming the primacy of secular law. And this is what gives me hope for the future, that someday we will see laws based on gender parity and equality for every Indian woman. Until then, this decision, such as also offer much needed protection and reinforce the security, the utility of secular laws in upholding women's rights. For more such video, please follow, watch the print. Thank you.